Hello and welcome. I'm Amritanshu Rai and you're watching Law of the Land on Raj Sabha TV. Today we bring to you the Supreme Court judgment on Triple Talaq. To discuss the issue, I have with me Mr. V. GIRI, Senior Advocate, and Mrs. Farah, Faiz, Advocate. Now for the highlights. Supreme Court holds Triple Talaq unconstitutional by 3:2 majority. Triple Talaq or instant talaq is not recognized by the Quran or the Hadith, rules the court. Several Islamic countries do not allow the practice of triple talaq as a form of divorce. The 5-judge Constitution Bench of the Supreme Court has disallowed triple talaq or talaq-e-biddat practiced by the Hanafi School of Muslims. Under this form of divorce, the husband can instantly obtain divorce by uttering talaq 3 times. 90% of Muslims in India practice the Hanafi School of Islam. The bench ruled in a 3:2 judgment that triple talaq is illegal and unconstitutional.
The Constitution Bench consisted of the then Chief Justice Jagdish Singh Keher, Justice S. Abdul Nazir, Justice Kurian Joseph, Justice Rohinton Fali Nariman, and Justice Uday Umesh Lalit. They delivered this verdict on a petition against the practice of triple talaq, talaq-e-biddat. In their judgment, the bench, through a 3-judge majority decision, ruled that instant talaq or triple talaq or talaq-e-biddat is invalid and unconstitutional.
The Attorney General at that time was very keen that talaq itself should also be set aside. Now only triple talaq or instant talaq has been set aside. Talaq hasn't been in its different forms. There is a delegated form of talaq which gives the right to the woman. There is, as I said, babarat, which is divorce by mutual consent, as it were, but under certain conditions. And there is also fusk, which is which amounts to annulling a marriage for various reasons. And then there's an act for dissolution of Muslim marriages, etc. So all those are still available and will remain intact. Talaq itself will remain intact with, as I said, reading the conditions that I believe apply to talaq as well.
The Constitution Bench yielded 3 separate judgments. The first was made by the then Chief Justice J.S. Keher and Justice S. Abdul Nazir. This judgment was in favor of putting on hold for 6 months the practice of triple talaq. It asked the government to come out with a law in this regard. This judgment said, till such time as legislation in the matter is considered, we are satisfied in injuncting Muslim husbands from pronouncing talaq-e-biddat as a means for severing their relationship. The second judgment was made by Justice Kurian Joseph, which held the triple talaq illegal and unconstitutional. It said, what is held to be bad in the Holy Quran cannot be good in Shariat, and in that sense, what is bad in theology is bad in law as well. The third judgment by Justice R.F. Nariman and Justice U.U. Lalit also held that triple talaq was illegal and unconstitutional. It said, it is clear that this form of talaq is manifestly arbitrary in the sense that the marital tie can be broken capriciously and whimsically by a Muslim man without any attempt at reconciliation so as to save it. This form of talaq must therefore be held to be violative of the fundamental right contained under Article 14 of the Constitution of India.
The first feature it reflects is a change of mindset, that you cannot have derogatory or discriminatory practices being prevalent in a society which is as progressive as India is today. It is not in consonance with civil society. I think that is the first and foremost message that goes across to the community. Secondly, the progress of women, the progress of Muslim women in the country is definitely linked with the fact that such practices are not permitted to go on. To say the same thing in other ways, if women can be thrown out of their houses, if women can be thrown out by giving a divorce simply at a unilateral, what is triple talaq? Triple talaq is pronouncing talaq in one go, without any intervention of any mediator, without any intervention of any court, without any authority, and simply at the wish of a man, he may ultimately throw out a woman from the house as well as throw her out from his life.
The minority judgment by the then Chief Justice Jagdish Singh Keher and Justice S. Abdul Nazir also clarified its view on several issues. It recorded that all the parties were unanimous that despite the practice of talaq-e-biddat being considered sinful, it was accepted among Sunni Muslims belonging to the Hanafi school as valid in law. Talaq-e-biddat is integral to the religious denomination of Sunnis belonging to the Hanafi school. The same is a part of their faith, having been allowed for more than 1400 years, and as such has to be accepted as being constituent of their personal law. The practice of talaq-e-biddat being a constituent of personal law has a stature equal to other fundamental rights conferred in Part 3 of the Constitution. The practice cannot therefore be set aside on the ground of being violative of the concept of the constitutional morality through judicial intervention.
Uttering talaq 3 times grants instant talaq to the husband, which is irrevocable. This situation left several minority women in a sorry situation. The Supreme Court judgment appears to have recognized this distress. Nishtha Malhotra with cameraman Prashanto Karmokar for Rajya Sabha Television.
The first judgment by former Chief Justice Keher and Justice S. Abdul Nazir hold the practice of talaq-e-biddat as integral to religious practice and gives it the status of fundamental right. Now, sir, the minority judgment that raises this question, making it part or calling it part of fundamental right, at the same time accepting that it is sinful but acceptable, right? Do you see that, there was something that was weighing when these words were being written in the judgment?
Yeah, the minority judgment written by the Chief Justice also goes into these questions, as to whether it is an acceptable practice in the Shariat, it is an acceptable practice in the Hanafi School of Law, whether it is considered as sinful or whether it is considered as tolerable. They also express a view that nobody seems to have accepted this as a good and healthy practice. They also have accepted the view that overwhelmingly the experts and the authors in the personal law also seems to have veered around to this view. They were of the view that this is not a healthy practice, and therefore, in fact, they quote the Prophet Muhammad, and who said that divorce by itself is a very sinful practice.
Correct.
And it should be avoided. And therefore, on that basis, it was mentioned, it was held that this is not a healthy passage, this should go. But where the minority judgment dissented from the majority judgment is that the minority judgment said this is part of the personal law of the community. And since it's a part of the personal law, it should be elevated to the status, or it should be considered to be part of the fundamental rights of the persons who practice that religion. And in that view of the matter, the courts cannot interfere with the personal law in the manner in which the courts interfere with statutory law. This was the minority judgment as such.
Yeah.
But otherwise, in paragraph 383 of the judgment, they have gone into these aspects, and that's why, the last declaration came that we are giving time for the
6 months
legislature to step in.
Yeah.
And in the meanwhile, we are injuncting the persons from. Therefore, to that extent, there is unanimity. There is really unanimity in all the 3 judgments.
That talaq-e-biddat needs to go.
Talaq-e-biddat is to go.
Go.
That's a judgment. That's a judgment.
But just that the minority judges, the judgment made by the minority did not want to clearly be seen as...
Yes, because they said that the court should be restrained in interfering into matters which have the status of a personal law.
Right.
That's on a legal question that the minority judgment was rested upon. As a matter of fact, the majority judgment of Justice Nariman put it on another basis, said that it's a personal law, but it is also transmuted itself into a statutory law under the Shariat Act, and therefore the Supreme Court has always had the jurisdiction to interfere with statutory law, and therefore since talaqi biddat has been recognized in the Shariat Act, that's of 1937, we are interfering with that, we are competent to interfere, and that is how they have interfered with it. They have declared it as arbitrary, whimsical, unconstitutional under as being violative of Article 14.
Ma'am, there was an attempt. There was an attempt to broad base the whole argument and include the entire process of talaq as it stands today, whether it be khula, mubarak, or the entire 3 types of talaq, out of which 2 are already acceptable in the Hadith and the Quran. Those 2 also. Ma'am, do you really feel that broad basing it at this point of time so as to, actually go where the mainstream of India wants to move is the way to go forward?
Actually, as you say that there are various kinds of talaqs, and talaq-e-ahsan and talaq-e-hasan is the acceptable by the Quran. I want to say that there is no description of talaq-e-hasan and talaq-e-hasan. There is no description, there is no differentiation about these type of talaqs in Quran. In Quran, there is only one type of description in Surah Talaq, chapter number 65, from verse number 1 to 5, and that is the only one type of one type of talaq, and there is no name of this kind of talaq. And if we are saying that is talaq-e-ahsan, talaq-e-hasan, all these kinds of talaqs are the describing by the Islamic scholars. So if we are the Muslims, it is our duty to follow the Quran only. We are not bound to follow the scholars.
Interpretation.
We are not bound, yes, not interpretation, but actually some of the NGOs like All India Muslim Personal Law Board, they are issuing all these type of, they are raising all these kind of issues, and they want to running their parallel judiciary. इसलिए and they have only the issues of marriage, divorce and maintenance, inheritance. So और ये सिर्फ उनका एक प्रोपेगेंडा बनाया हुआ है.
मैम, आपको लगता है ये जो जजमेंट आया है इसका व्हाट इज गोइंग टू बी द इम्प्लीकेशन, उसका असर क्या हो सकता है आपके मुताबिक?
Actually, it is very good. It is a very good step, but I am not very much satisfied with the judgment, because this judgment would becomes with the full majority. It is a 3:2 ratio, which is very bad according to me.
So you mean to say
this case would be cover all the aspects like polygamy, nikah halala and triple divorce or triple talaq or talaq-e-biddat. Actually, Muslim women are very much suffering by the polygamy, by the bigamy and maintenance. If they registered a case in the court under the section of 18 domestic violence and 125 CRPC for the maintenance, in the written statement the husband said that I have given the divorce to my wife, I am not liable to give the maintenance, and जब तक वो अपना पूरा केस लड़ती है, that the person get married, second married, and there is no option for the women. What is the legal status of that lady at that time?
Right.
Where will she go?
Right, ma'am. It's time for us to head into a break. When we come back, we will talk more about what has been included in the Supreme Court judgment on triple talaq. Welcome back. The minority judgment by the then Chief Justice Jagdish Singh Kehar and Justice S. Abdul Nazir records the whole gamut of Sharia law relating to divorce and separation. It also records the Islamic countries that have disallowed talaq-e-biddat as a form of divorce.
The Supreme Court verdict is not just about divorce, but about giving a sense of equality of status and empowerment to all women. There has been a sea change in the last 2 decades. In 1986, after the judgment of the Supreme Court on Talaq, in Shaira Banu case, nobody was willing to discuss triple talaq, but now women are more aware, and this change has come because of education.
I had made submissions which are also noted therein. That is, that for a Muslim woman to get talaq, she has to go through, there is a 1939 Act, and she has to go to court on codified reasons, just like the Hindu Marriage Act, on codified reasons on which she can get talaq, or what is called khula. But for the Muslim man, he doesn't need to go to court. He can still do, because what the court was considering in this case was just instant triple talaq. It has not gone into the other modes of talaq, where a husband can give, say, talaq over a period of talaq, which is called, this was talaq-e-biddat, that is called talaq-e-hasan, which is, say, over a period of 3 months with a arbitration.
The minority judgment by the then Chief Justice Jagdish Singh Kehar and Justice S. Abdul Nazir attempts to record the concept of talaq. According to the judgment, the Islamic law on divorce is classified into 3 categories. Talaq understood as a means of divorce by the husband. Khula is another mode of divorce by the wife. The third category of divorce is mubarat, divorce by mutual consent. Divorce by husband is also of 3 kinds: talaq-e-ihsan, talaq-e-hasan and talaq-e-biddat. Talaq-e-ihsan is approved by the Quran and Hadith. It's a single pronouncement of talaq by the husband, followed by a period of iddat, abstinence. The duration of the iddat is 90 days or 3 menstrual cycles. If the couple resumes cohabitation within the period of iddat, the pronouncement of divorce is treated as having been revoked. Talaq-e-ihsan is also approved by the Quran and Hadith. There are 3 pronouncements of talaq interspersed with abstinence, iddat of 1 month each. This is also revocable but is considered irrevocable after the utterance of talaq for the 3rd time in the 3rd month. Talaq-e-biddat is neither recognized by the Quran nor by Hadith. This comes into effect by one definitive pronouncement of talaq, such as I talaq you irrevocably, or 3 simultaneous pronouncements like talaq, talaq, talaq uttered at the same time. In talaq-e-biddat, divorce is effective forthwith. The instant talaq, unlike the other 2 categories of talaq, is irrevocable at the very moment it is pronounced.
The majority community, the Hindu community, is already governed by a legislation enacted by the Centre Parliament. This only relates to the Muslim woman, and according to several other, like among the Shias, there are other this thing where triple talaq is not an accepted mode at all. But today, no Muslim woman will suffer a divorce with a triple talaq, the mode of triple talaq, and the marriage today cannot be dissolved by triple talaq. But what most important thing for today's thing is, I have heard that in the winter session of the Parliament, this government intends to bring a bill and to make triple talaq punitive.
The minority judgment by the then Chief Justice Jagdish Singh Kehar and Justice S. Abdul Nazir also made a mention of the Islamic countries like Algeria, Egypt, Iraq and Morocco, who despite being a theocratic state do not allow the instant type of divorce like talaq-e-biddat.
Talaq-e-biddat has a precedence but is not recognized by either the Quran or the Hadith. Moreover, several Islamic countries have disallowed it. Nishtha Malhotra with cameraman Prashanto Karmokar for Rajya Sabha Television.
The Attorney General had argued in favor of disallowing the whole practice of talaq, but the court limited it to talaq-e-biddat or instant talaq. Why do you think the court limited itself just to talaq-e-biddat? Because it is, if it is creating so much of pain among a sizable population of women, the minority women, why do you think the court limited itself to talaq-e-biddat? Was it because most of the petitions were targeting only talaq ke biddat and not other aspects?
Actually, it is also a very big question for me. It is a rare chance for the community कि ये उनके लिए बहुत ही मुश्किल से हाथ आने वाला चांस था जो उनको मिला था, और उन सबको उम्मीद थी कि ये सिर्फ तलाक़ बिदत को ही नहीं कवर करेगा, पॉलीगैमी को, ऐसा ही सेड अर्लियर, पॉलीगैमी को भी कवर करेगा, निकाह हलाला को भी कवर करेगा. बट चीफ जस्टिस क्लियरली सेड दैट वी विल कन्फाइन ओनली फॉर द तलाक़ बिदत. तो लेकिन हम लोगों को लगा कि भागते चोर की लंगोटी सही, तलाक़ बिदत ही अगर डिस्कस हो जाए तो कुछ तो रिमूव होगा, कुछ तो रिफॉर्म होगा, कुछ तो चेंजेस आएंगे. कोर्ट ने अपना काम कर दिया, तलाक़ बिदत को सुना और उस पर अपना जजमेंट दे दिया. एज वी आर hearing that in the winter session the parliament is going to bring a bill in the parliament session. So it is my request to the government कि ये एक बहुत 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 मुश्किल से हाथ आने वाला चांस है. If you want to give a real relief to the Muslim community, तो इसको politicize मत कीजिए. एक फैमिली ड्राफ्ट लेकर के आइए which covers all the aspect of marriage, nikah halala, maintenance, inheritance and the divorce.
Right, ma'am. So, why do you think that the court actually limit itself? And just trying to understand, when it had a chance, an opportunity, and there were various petitions that were raising almost all kinds of issues relating to the personal laws of the minor.
I believe it must have been the constraints of time.
Okay.
That must have been one of them, because the focus was on talaq bidat.
Okay.
Because that was the most important aspect that was being debated upon.
Right.
But as my friend said, the court had a chance to go into the other aspects also.
Mm-hmm.
But you know, they were sitting during the summer vacation.
Yeah.
And the Chief Justice himself was to retire in August, and being such an important issue, I think they had kept apart several days of hearing for this, and the hearing actually went on for several days also.
6 days.
Yes.
Yeah.
But in the beginning, I think, I believe that the what weighed with the court, and that was a call which was taken by the Chief Justice in the beginning. It is obviously for the Chief Justice to lay down a framework within which the matter will be debated upon. And I think but the court also felt, I think all the judges felt, that if you go into other aspects, then the debate could get very broad-based.
Broad-based.
It may not be possible for them to come out with a judgment during that time.
So it was just to get the focus.
Yes, but the focus was therefore on talaq bidat. But when the arguments were going on, there were references to the other aspects also, but essentially to point out why this practice should be taken as the most harmful among the lot. And therefore, there were arguments on that basis. But maybe there will be a chance to go into the other aspects at a later point of time.
So
but what is important is that the majority judgment have apparently held that the talaq as such, talaq bidat, and this practice has gained a statutory recognition under the Shariat.
That's the legal.
That's a legal point on which the majority judgment is predicated. That is rested. And that would obviously be of some...
Opens up a door
yes,
to scrutinize all aspects relating to the statute.
Yes, so, and at any rate, I think now if the government is responding with a law in the winter session of the parliament, obviously the government can step into these areas also.
And how important is it to make triple talaq punitive in the proposed legislation that the government wants to?
Well,
taking a cue from the Supreme Court, obviously.
Yes, it's obviously taking it forward from the Supreme Court judgment. And I don't know, I have not seen the punitive provision as such.
Yeah.
I have not seen that as it is. They say that it is there, that the maximum sentence.
The proposal is to for 3 years.
Yes.
Well, competence they have. Obviously, the government has a competence to make it punitive. But when it is declared to be unconstitutional by the Supreme Court, then obviously the government can step in and say that what is held to be illegal by the Supreme Court itself, we are just translating it into a law by making it punitive.
Right.
If you continue to practice what has been declared by the Supreme Court to be illegal. Therefore, that if it comes about, obviously it also reflects the intention of the legislature or intention of the government to I mean, to take it very seriously and take it forward from there. Well, leave it at that, because let's see how things pan out once the legislature passes.
Got it, sir.
Right.
Moving on, my colleague Nishtha Malhotra spoke to Mr. Mukul Rohatgi, former Attorney General, to get his point of view.
Sir, what is the most important aspect of the Supreme Court's judgment on Triple Talaq?
See, this is the first judgment of the Supreme Court in the last 70 years, where the Supreme Court has said that a practice which was considered as a religious practice, a part of religion, the Supreme Court has come down heavily on that practice and said that even these practices must meet the test of fundamental rights. And any practice, whether it is with marriage or whatever, will be struck down if it is contrary to fundamental rights, contrary to rights of gender equality. तो मेरे हिसाब से बड़ी अहम जजमेंट है, और जो मुस्लिम पर्सनल लॉ बोर्ड ने कहा कि भाई ये हमारा रिलीजन है, इसलिए आप इसमें दखलंदाजी ना करें, सुप्रीम कोर्ट ने उसको रिजेक्ट किया, और ये जजमेंट जो है ये एक पाथ ब्रेकिंग जजमेंट है.
Sir, how does it help the women of the minority community?
जितनी भी मुस्लिम औरतें हैं जो बेचारी सफ़र कर रही थी, जो आदमियों से कम दर्जे की मानी जाती थी, उनका दर्जा सुप्रीम कोर्ट ने उतना ही किया है. संविधान में दर्जा आदमी और औरत का बराबर है. ये प्रैक्टिस की वजह से दर्जा नीचे था, सुप्रीम कोर्ट ने दर्जा ऊपर किया है. और इस तरह के तलाक टेलीफोन पे कहना या गुस्से में कह देना, ये तलाक सब गलत है. और अगर ये तलाक कोई किसी को करता है, किसी औरत को करता है, तो उसको अख्तियार है ये कहने का, या कोर्ट में जाने का, या पुलिस को कहने का कि ऐसे तलाक से मुझे कोई घर से बाहर नहीं निकाल सकता. एक चीज़ मैं फिर भी कहना चाहता हूँ, ये सुप्रीम कोर्ट का फैसला है, केंद्र सरकार को इस पे कानून बनाना चाहिए.
Thank you, sir, and ma'am, for joining us on this discussion. It's time for us to end the show. You can email your suggestions and comments to law.rstv@gmail.com. You can also watch our shows on the RSTV page of YouTube. We'll be back with a new issue and a new episode. Keep watching Raj Sabha TV.